Yes, good evening to the participants of my all the SLW 600, SLW 616, SLW 646, SLW 670 because this class is useful to each and everybody. The reason is the first question is compulsory question which carries 40 marks and the rest of the questions carries 30 marks. Overall that you have to do the how many? 3 questions. Out of 3, first is a compulsory question out of 5 questions. Is it clear the pattern? Say yes.
Yes, Professor.
Very good. We appreciate. See, why I have giving this time to time, if you read how to swim it for 6 months theoretically, and you read the Encyclopedia of Britannicana, read the Encyclopedia of the Americana, and all the things. But still, unless until you jump into the water, you cannot make the theoretical into the practical. A theoretical will come to the practical at that instance only. We applied. That means you have to do in the Iraq and P-FIRAC model, the case briefing is concerned. And I gave the assignments to each and everybody, including the SLW 600, that is the advanced legal theory, that I told them, prepare the case brief in the form of P-FIRAC model, and I gave a reported case, BV Hawa versus Saif Ali. Here, it is common to each and everyone. The reason is, I would like to ask you the reason. What is the difference in the case briefing and Iraq model? Anyone can unmute and give me the answer? Anyone can unmute and give me the answer? I repeat the question. What is the difference between P-FIRAC model and Iraq model? Yes? I said, if you don't know, you say pass on. Don't kill my time.
Sir, you said P-FIRAC mode involves court decision. Iraq mode, you may just have facts and
I appreciate Margaret.
produce that Iraq.
I appreciate Margaret Monoseba. In the P-FIRAC model, the whole judgment will be given to you. Out of it, you have to make the P-FIRAC things. Only the difference is procedure. Once the procedure over, because facts we will give in the Iraq model, that is the problem question. The other thing is, Iraq is the common to each and every one. That is the international style of making the problem solving questions. And wherever I taught, from the 2004 to 2015 in the UDSM, as a full-timer and the part-timer and adjunct professor in the various other universities, I taught the law of tort and private international law and the law of contract and the legal methods. But whenever I teach the law of tort, I give them this Iraq model of saying. That's why I already told you that in the LST, Law School of Tanzania, they will grill you in the case briefing. And when you become an expert at that instance only, when you do the practice. I told you to make the practice and send to me, but no one has made it. Timothy, are you present? Because I did not see who are the participants here. Now I could see it. Who are the participants here? Because I could see the list. Oh, this participant list is not coming in the different way it is coming today. Okay. Rostra Mafuga, you joined now. Okay, now the participant list is here. Yes, I could see it. Timothy is present or not. He is the only candidate from the SLW 670. That is nothing but advanced intellectual property law. I could see here the Bibian Kilio and Fidelis Kitange. We are welcome. Fortuna Govita, Julia Gosbert, Margaret Moseva. Suppose, please forgive me if I pronounce your name in wrongful spelling, not wrongful pronunciation. Yes, then the Julia Gosbert, Margaret Moseba, Petrolina Chuma, Rimek Meruba, Rosta Mafuga, Sabina Isa, and these are the people I could see it in my screen. I don't know whether the other people also there or not because I could not see that. Sabina Isa. These are the people I could see it. But Timothy is absent, to whom actually today is the scheduled period. Today is the scheduled period for the SLW 670. Either 670 or 600, 611, 646. It doesn't make any difference because the rules are the same. Anyone in your class, if you tell me the other name of the Donoghue versus Stevenson case law, I repeat the question. Anyone in your class or the participants can tell me the another name, synonym for the Donoghue versus Stevenson case law. If you don't know, you say pass on. If you know it, you give me the answer. Sir,
Pass on,
Zawadi. Okay, I can give the Zawadi to you. Okay, only 10 seconds I will give the Zawadi. Yes? Please repeat. Say what you want to say. Margaret Moseva, keep your gadget very near to your mouth and speak. What is the another name for the Donoghue versus Stevenson case law?
I just wanted to say duty of care.
I say another name of the title of the case law. I did not ask you the principle involved in that case law. Say pass on, I will give the answer.
Pass on.
McAllister versus Stevenson. Can I write it? What I write it, I can show you the I can show you the original case law. I can show you the original case law. Did you see the original case law? Say yes or no.
Yes.
Yes, Professor.
Read.
Yes, Professor.
Donoghue in bracket Macarista versus Stevenson.
The another name for the Donoghue versus McAllister versus Stevenson. Did you know this another name also there for this case law? Till now? Keep your hand on your moyo and tell me.
We have no need today, sir.
That means you miss my class, you miss many things. Repeat. Repeat. If we miss your class and we miss many things, repeat. Polisana. Doesn't matter.
We miss
If you repeat
your
or
class,
don't
we
repeat,
miss many
doesn't matter.
things.
Okay, now let us come to the point McAllister versus Stevenson, because why I have chosen this case law means the case law is having many other things. If you happen to see the original case law, see the original case law I have shown you here. This is the original case law. Just I'm scrolling. You can check how many pages are there. Just I'm scrolling. You check how many pages are there. Okay, now I go a bit faster. Then I'll go Moisho. Yes, now Pole Pole. And this is the end page. Now if you observe it, how many pages are there? Say!
32. 32, Professor.
I appreciate.
32 pages.
I appreciate means, yes, Tosha. Other people need not to say. There are 32 pages case law is there. If I give the 32 pages case law in your examination, you will be Kufa. Say. I say what I said now.
You will
We
die.
will be Kufa.
Yes. My purpose of asking is, are you with me or not? Whether we are sailing the same boat to reach to the destination or not. That is my purpose of asking you. Is it clear? Say yes.
Okay, Professor. Yes,
Yes,
it's clear.
Professor.
Okay,
Yes.
Professor.
Yes. That's appreciate. So now why you have chosen this case law means, this case law is very much famous case law. And there are 32 pages are there in this case law because there is the ascending judgments, there are the descending judgments. And the permanent figure which is the ascending judgment is Lord Atkin. And this McAllister versus Stevenson case law, and how do you read it? And I told you already that why we need the square bracket, why don't we need the circular bracket? Anyone can give me the reply? I already told. Give me the reply. Or if you don't know, you say pass on. But don't kill my time.
Pass, sir.
I told very clearly like a kasuku. Najua kasuku. Sema Kiingereza?
Yes.
Parrot. I told you in the today class also I told you, when I was dealing the 9:10 to the 9:15 to the 10:15 class. Whenever the reporter having the volumes in a year, then the year should be in the square bracket. I repeat, whenever the reporter here, which is the reporter here in this case law, which I highlighted?
All ER.
1932.
All England report. All England report is the reporter or journal where this case law is cited or mentioned. All England report is always in 4 volumes in a year. That's why number 1 will not be written, but number 2 will be written, number 3 will be written, number 4 will be written generally. For instance, there is no 4, let me presume it. Either 3 will be written because in a year 3 volumes are there. In each volume, there are how many issues? If it is a quarterly, there are 4 issues are there. And the 4 issues, when you get any reporter, any journal having the many issues in a year which are cited the decided cases, and that should be in the square bracket. That means all India reported should be in the square brackets. King's report, King's bench is the square bracket, Q's bench is the square bracket, appellant cases in the square bracket, and the Times Law Review is the square brackets, and the Weekly Rod Reporter is the square brackets, because all these reporters have the volumes in a year. What about the Tanzania Law Report? It is only 1 volume in a year. Hence, it will not be in the square bracket. It should be in
Brackets. No more brackets.
what is the name of the bracket?
Close bracket.
What is that?
Hyphen.
What is that? Repeat.
Hyphen.
Not hyphen. What is the type of the bracket? Say don't know. Kasram, I will give the answer. Don't waste my time.
We don't know.
It is a circular bracket or it is a round bracket or in the Shervaro style parenthesis. Is it clear? Say yes.
Yes, Professor.
Yes.
Yes, Professor.
See, this is the total case law which is run into the 32 pages. But I can make it so short in the PIFIRAC model again, which is useful to the 600 as well as to the other people also, case briefing or outlining the case. The first and foremost, the procedure comes. In the left hand margin, procedure you have to write it. And I already told in the today case law, the name of the case law, which is in, or the title of the case law, which is in italics, and the small v, you don't write the v, capital VS or versus, small v dot or full stop. Later it ends with the comma, and the citation of this case law, if you want to see, it is a square bracket 932 All England report. Of course, the representation is there one, but it is also given in the, see, these are all the other reporters. I don't know whether you saw it or not. Also reported in the 1932 square bracket AC appeal cases or appellant cases 562 and 101 LJPC, even I don't know what is the acronym or the initialism of the LJPC unless until I research it. TLR, don't say Tanzania law report. What is TLR which I have given here? If you know it, you tell me. If you don't know it, you say pass on. Don't kill my time.
Pass on.
I referred just before. Times Law Review. What I said? Repeat.
Times Row Review.
Yes, which is always in the square bracket because it is in volumes. Then, of course, the Social Joe, I don't know this also, but it is published in many journals which is having the volumes. Hence, in everywhere, you could see the year should be in square bracket. Of course, this is a House of Lords decision, and there we can say you can write McAllister versus Stevenson, or you can write Donoghue versus Stevenson. This Donoghue is a male or female? Anyone?
Female.
Yes?
Male.
A female.
It is a female, Mrs. Donoghue. Mrs. Donoghue went with his what? His friend, paramour or fancy? What? A friend or a husband? She went with the lover, and Mrs. Stevenson is a fancy. Lover, fancy, wife is different. I believe that you know it. I need not to explain. So, and what she drank? Haraka.
Neck. Snail.
Yeah.
What she drank?
Ginger beer.
She drank the ginger beer. They ordered the ice cream. Later on, they drank the ginger beer, which is in which type of the bottle?
Yeah.
Opaque.
It is not opaque. Opaque means you cannot see it. Not transparent. Transparent like a Q mirror. You can see it there from what is the content in the bottle. Transculent means katikati. You cannot see it. You can see in the abrasive way. And the opaque, you could not see at all. with your naked eye or with any other spectacles or opticals. Opaque bottle, it is a sealed one. What is inside the opaque bottle? After pouring the tumbler one glass, later on pouring the second tumbler, what they found in that bottle? Not in the bottle, in the tumbler, coming out of the bottle.
Nail.
Yes?
A snail.
Rotten snail. Not a snail. A decayed snail. A rotten snail. A putrid snail. A dead snail. Is it clear? Say yes. Yes.
Yes,
Now,
Professor.
in the second tumbler, when she was going to drink it, at the time, she felt it, the snail, rotten snail was floating in the tumbler, and hence she got the nausea and she became unconscious, and she was supposed to be hospitalized for that few days. And she filed a case against whom? The barmaid, or the bar owner, or the agent, or the manufacturer, because see, when you come the product from the manufacturer, it will not directly come to the bar. The bar, it will come only the last point. So first the manufacturer, next, comes next? There is a regional, countrywide distributor is there. A regional and a countrywide distributor is there. It comes to the first, the country distributor. From the distributor, regional agent. From regional agent to the respective bars. From the respective bars, it comes to the waitress or waiter. In the bar, generally, waitress is there or waiters are there. Give me the answer. Otherwise, you say, pass on. Don't kill my time.
Hassan.
Hassan.
In the bar, to attract the customers, a female Rambo is there. Waitress. And the waitress bring the bottle and she shows whether it is chilled or not and ask you to touch it, the bottle. If it is a chilled bottle, you say, yes, you can open it. Some people will not take the chilled beer, they will take wugu wugu, means kati kati, a warm one. So he will show it, then she opens with the opener the bottle, and sometimes she will pour, or sometimes it will kept on the table. So now the question comes. There are many people, participants are there. Yes, I have to allow them. So now the question comes over there. Yes, select all, then I say let in. So now the question. So she felt it and she filed a case against the manufacturer. Who is the manufacturer here in this case law? If you know it, you tell me. If you don't know, it's a pass on.
Stevenson.
Stevenson is the manufacturer. But the question comes, is there any contract between the consumer and the manufacturer? Say.
No.
There is no contract. And she cannot file a case against the waitress. She cannot file a case against the barman. She cannot file a case against the agent. She cannot file a case against the distributor, but she can file a case against the manufacturer because it is the manufacturer who produced the ginger beer, where the quality control duty is there and they have to observe it before it is released to the market. Even though there is no contract, but under the thought one can file a case because of the negligence on the part of the quality control. So a person who is a party at the end, who is a consumer, can bring an action against the manufacturer because the bottle is sealed bottle. It is nowhere tampered anywhere. Hence, there is no break of chain. In the Latin terminology, we can say novus actus intervenus. There is no break of chain, and hence manufacturer would be held liable. And who is the consumer here? A consumer here is the neighbor. So a neighborhood principle is evolved over there. A person who consumes the goods, that should be worth enough to consume. If it is not in the consumable nature, then it is the manufacturer would be liable because there is no tampering of the seal in the opaque bottle. And hence, she filed a case under the tort of negligence, but not on the contract. And this case law shows the privity of contract is a fallacy. But earlier, Winterbottom case law is there. In the Winterbottom case law, it says a party should be a party should be in contract, then only they can file a case. No third person can file a case. So this is the case law where we can make it out. 32 pages are made into the, see here, I made it cut short. And actually the case law is Mrs. Donoghue went to a cave with a friend who was bought her the ice cream and a bottle of ginger beer. The ginger beer contained a decomposed snail. Mrs. Donoghue suffered from the personal injury due to this and proceeded to claim against the manufacturer, which was successful and resulted in the establishment of the modern law of negligence and the neighborhood test. This is the gist of the case law. This is the summary of the case law. And the summary and gist and head note comes in the P-FIRAC model. After writing the title of the case law with the citation, Bennett, after writing the judges' names, then comes the head note or gist of the case law or the crux of the case law, and that is nothing but the summary of the case law within 4 lines or 5 lines that gives the complete picture of the case law. So here we can say this is the summary of the case law. And what is important is very much important. What is the facts of the case law? See, Lord Atkin, Donoghue versus Stevenson, he has given the judgment. And when you say the facts of the case law, there are various facts I have given here in this case law. See, while at a cafe in Scotland, Donoghue plaintiff drank from a dark opaque glass bottle of ginger beer that was purchased for her by her friend. The beer was manufactured by the Stevenson defendant. After Donoghue has consumed about the half of the bottle, she claimed her friend poured the remainder into the tumbler, and that is when the decomposed remains of the snail floated out and they nauseated Donoghue and causing her the shock and severe gastroenteritis. Sir, we don't know how to remember the gastroenteritis. If you don't remember, then you can. She became a sick. Tumia bongo. Sir, nime sahau you nyombani. Never sahau you bongo in the nyombani. Carry with you. Is it clear? Say yes.
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 Because Donoghue was not the purchaser of the ginger beer and she could not sue the Stevenson for the breach of contract. Instead, Donoghue sued the Stevenson, who is the manufacturer, for breaching the duty of the reasonable care. She alleged her oath to the ginger beer consumer to ensure that his beer was manufactured and inspected in manner that would not be allow the snail to get into the bottles. The first judge to decide the case was found for the Donoghue, but the next court disagreed and dismissed the case. Donoghue appealed to the House of Lords. This is the facts of the case law. The 32 pages case law which is given, this is one style of it. And another style here he has given, which is less time. And another style of the fact here I have given. Mrs. Donoghue went to a cafe with a friend. The friend brought her the bottle of ginger beer and an ice cream. The ginger beer came in an opaque bottle so that the contents could not be seen. Mrs. Donoghue poured half of the contents of the bottle over her ice cream and also drank some of the bottle. After eating the part of the ice cream, she then poured the remaining content of the bottle over the ice cream and decomposed snail emerged from the bottle. Mrs. Donoghue suffered a personal injury as a result. She commenced a claim against the manufacturer of the ginger beer. So sometimes, who poured the second time? The second time poured by the fancy, is the lover, the friend. Either the first time she poured herself, doesn't matter. Because of the courtesy, what we do, we pour it as a courtesy to a woman. Am I right? Say yes or no.
Yes.
I appreciate. So here I have given the facts of the case law, which is in very less in number, and here I have given the very facts of the case law, only 3 lines. Depending upon the time factor is concerned, you have to give the facts, which are very much relevant over there. Here I can make the plaintiff, the claimant, as they are now called. Claimant means plaintiff. Claimant is the USA terminology. And the plaintiff is the British terminology. Is it clear? Say yes.
Yes, Professor.
Mrs. Donoghue drank from the bottle ginger beer. This was brought to her by the friend in a cafe. The bottle was opaque, and when she poured the content into her glass, she noticed a decomposed snail in the bottom. The snail allegedly caused her to become sick. See, gastroenteritis, if you don't know, use the terminology sick. That's why tumia bongo. If you don't know, don't show your ignorance to the examiner. I repeat, don't show your ignorance to the examiner. So Mr. Donoghue did not hold a contract with the beer manufacturer, so the only way she could seek a legal redress was through the tort of negligence. And the last fact C I give, D means defendant. Manufacturer sold the ginger beer in opaque bottle to a retailer or to the agent to every way. A retailer resold to the A, and A is an agent who gave it to the C. C means here a bar owner, or the C alleged that also she became seriously ill. C means consumer, and she gave it to the consumer for drink, and the consumer alleged that she became seriously ill and should sue the D for negligence. See, the entire case line is given only the 2.5 lines. Am I right? Give me the answer. Sir, we don't know. Say we don't know.
Don't know, sir.
I don't know,
You
sir.
can express the case law. When you thoroughly understood the case law, you can immerse the fact which are relevant to the case law. And always keep in the mind, you know the many things in the tort law are in the writing these cases, but time factor. What factor? Say what factor? Please say or say don't know.
I don't
Time
know.
factor.
I told you just now, time, T-I-M-E, time factor. Mood. Is it clear?
Yes, Professor.
The point of asking is, I would like to get the response from you. Otherwise, I did not know whether you understood me or not. That is my purpose of asking you from time to time. So facts you have to write depending upon that factors. Time factor is concerned. How much you can write it. See, here I have given the model. How many times, the different ways of the presenting the fact. See, here I have presented 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 lines, and here 1, 2, 3, 4, 5, 6, 7, 8 lines, and here only 3 lines, and that will be the 2.5 lines. Is it clear? Say yes.
Yes. Yes,
Then come to
Professor.
the facts are over. Issues. What is the issue? Can anybody will tell me? What is the issue in this case law? Sir, we studied in the undergraduate very long back.
Whether
sir,
there is
we
a
don't know.
negligence on the part of manufacturer.
Repeat.
Whether there was a negligence on the part of manufacturer.
You can use in that way also. Whether there is a liability of the manufacturer would be there for the plaintiff who is the consumer. So issues you can frame in a different style depending upon your perception. Does the defendant owe a duty of care to the plaintiff being as there is no contractual terms? Or is there liability in the negligence for the injury caused by another in the absence of a contract? Or does a manufacturer of a ginger beer bottles owe a duty of care to the end consumer while he could not directly sell to him but only via distributor? There are many ways to frame. It depends upon your perception and the language and the legal language, you know it. So this case law gives that privity of a contract is a fallacy. That means there should not be a privity at all. There should not be a party at all in the negligence. Number one. Number two, it's the development of the negligence is made in this case law. Number three, neighborhood principle has evolved in this case law. Who is a neighbor? Your neighbor is such a person who is the consumer. Is it clear?
Yes.
Yes.
So
Yes.
you can frame it only one issue enough. Only
Yeah,
one issue
yes, sir.
enough. Whether the manufacturer is liable for the negligence in the manufacturing and where the plaintiff and the consumer victimized. Liability is there or not. Manufacturer liability is there or not. Enough. One line. Enough. And then what are the rules are there? If you happen to see the case law, the rules given is Muller versus AG Bar and Company Limited, Hadley Byron versus Heller, and Dorset Ash Company versus Home Office, and Capro Industries PLC versus Dickman, and Brigham Waterworks Company Limited, and Saltradhar versus Neutral Environmental Research Council, and the Mitchell and another versus Glasgow City Council, and Tomlinson versus Gogleton Borough Council. Sir, can we write all those case laws, sir? Answer is not necessary. Because each one has given their own stand. They use the different case laws. But you should use that case law which is favorable to you. That means manufacturer should be held liable. And there I did not mention the Winterbottom case law here. Again, there is a Winterbottom case law is there where it says a party to the contract can have the right to sue. Means privity of contract is there in the Winterbottom case law. And Winterbottom case law judgment is overruled in the Donoghue versus Stevenson case law. So you can use one or two case laws or three case laws enough because time factor. What factor? What factor?
Time factor.
I appreciate. I should have to get the answer from like that. Then I know that you are and myself is traveling or sailing the same boat to reach to the destination. Now the application. Use the first issue. Whether the manufacturer is liable for or not. Yes, Mullin case law is enough. One case law is enough. Mullin case law, you can use it. And here I made many case law, but if you just write the Mullin and Capro Industry case law also you can use it. Yes, one or two case law you can use it enough. Not necessarily that you can use all the case laws. Because every case law shows a different. The reason is proximity of the cause is there or not. Reasonable forcibility is there or not. Yes, the reasonable forcibility is there, which says about the Birmingham Waterworks Company Limited case law. The Mullins versus K, yes, it is the burden of the manufacturer to see that the goods will be manufactured in a consumable in nature, worth enough to consume. Two case laws are in. Don't mention the Tomlinson and Coughlin because they are all the equivalent case laws where we can make application. Use the first issue and use the one or two case laws enough, and you can give your argument over there. And the argument you can give in this way. Application Stevenson appealed to the inner house of the contract of the sessions, and Mullen versus AG Bar and Company Limited, where it was held that no duty of care could arise in the absence of the contractual relation. Thus, the appeal was disallowed. Majority of the judge were the Lord Hunter have dissented against it. But here they say Mullen versus AG Bar, it is not applicable over there, they said. But this case law is fallacy, and Winterbottom case law is a fallacy. And now the duty of care would be there under the new concept of the negligence. Hence, the manufacturer is held liable. Enough. Time factor. Write 4 or 5 lines. In conclusion, what do you say? What is held? This claim was successful because the case established the modern law of the negligence and established the neighborhood test. Or you can say the case has established the principle that a manufacturer must take the reasonable care to ensure that his products are safe for the consumer to use, and has set a standard for the level of the care that a manufacturer must take to fulfill the duty. And if there is no contract between the consumer and the manufacturer, still manufacturer is liable under the tort of negligence. Or you can write, House of Lord, as it then was, held that the manufacturer, Stevenson, that the defendant owed the Mrs. Donoghue a duty of care not to cause her injury. This is sometimes referred as establishing the neighborhood principles. So, in 1 line, 2 line, or 3 line, you can make the conclusion because only one issue is there, 1 paragraph of the application and 1 paragraph of the conclusion. And the reasoning is concerned, yes, you can write the reasoning. Why the manufacturer is liable? The reasoning, your own opinion or reasoning can show, or you can show the ratio dissidentity also. Number 1, negligence is a distinct and a separate element of tort law because it's not a contract. And a duty of care in tort does not require the contractual relationship. There is no necessity that there should be a contractual relationship when the tort element has come, when the negligent element has existence over there. Number 3, manufacturer of the products owe a duty to those who intend to use their product. Whenever the manufacturer is preparing any product, it should be free from harm or injury if anybody consumes it and is worth enough to consume it. That is the whole story behind the thing. See, why I have given all these points is, you have to read the entire case law and find out what are the relevant facts are there, which has very much, depending upon the time factor is concerned, you have to insert the facts. Depending upon the time factor is concerned, of course, issue is only one in this case law. And the application is 1 paragraph. And support your cases which is favorable to you, and don't support the cases which is not favorable to you. And then you can write the hell. If one issue is there, how many conclusions comes in if there is one issue? Anyone? Because Cisco WebEx at any time will stop it because already indication I got it. Only 5 minutes are left. Out of it, 3 minutes are over. Still 2 minutes are left. If the issues are one, how many conclusions will come?
1 conclusion.
It is a mathematics. 1 issue, 1 paragraph of the application, and 1 paragraph of the conclusion. Enough. If you don't agree with the court decision, my view, keep the side heading. My opinion, keep the side heading. and you can write your own opinion also. Is it clear?
Yes, it
Yes,
is.
Prof.
So
Yes,
now
Professor.
I have given one problem question in each and every paper. That means legal theory, advanced law and economics, advanced intellectual property, advanced international dispute settlement law. One question I have given for the other people problem depending upon what is decided in the Tanzania. And for the SLW, I have given one judgment which is decided in the Tanzania, which consists of the 3 pages. Yes, you want to say anything? Sikiliza mimi darasa, asante sana na shukuru sana, Mungu akubariki na kukulinda.